having me.
All right, we'll move on now. Reactions have continued to swell after the Supreme Court on Friday upheld the death sentence imposed on Maryam Sanda, daughter-in-law of a former national chairman of the People's Democratic Party, over the killing of her husband, Bilyamin Bello. Sanda was convicted on January 27, 2020 by an Abuja High Court, which found her guilty of fatally stabbing Bello at their Maitama home in 2017. She was subsequently sentenced to death by hanging. She had spent about 6 years and 8 months at the Suleja Correctional Center before President Bola Tinubu granted her clemency, reducing the sentence to 12 years imprisonment. The Supreme Court faulted Tinubu's intervention, ruling that it was inappropriate for the executive to grant clemency in a homicide case while an appeal was still pending. And I'm being joined by a lawyer, Mary Odewuyi, and she'll be sharing legal perspective to this. Mary, thank you so much for coming around.
Thank you so much for having me.
All right, so Maryam has already spent about 6 years in prison. Given the weight and circumstances of this particular case, should a death sentence still stand, or is presidential clemency more appropriate?
Okay, thank you very much. So I would say from a legal standpoint that the length of time spent in custody does not invalidate a death sentence, particularly where it has been affirmed by the court. On the other hand, the issue of clemency is at the discretion of the executive and not the court. What the court will always focus on is whether or not this case has been proved beyond reasonable doubt. For the issue of clemency, at the discretion of the executive.
Okay, so the president exercised executive powers to grant pardon, we understand, yet the case remains pending in court. So was the president ill-advised at that time in taking that step?
Well, I would say that, well, respectfully, the president did not respect the rule of law. I would also say that this power was used to overlap the autonomous power of the judiciary. It is clear that we have 3 arms of government in Nigeria. We have the legislative arm of government, we have the executive arm of government, and we also have the judiciary. We know that for the legislative, it is their duty to make laws. We also understand that for the executive, it is their duty to implement, to enforce laws. And we know that for the judiciary, we interpret the law. I would also say that this act of pardon is not sustainable. And that is why I like to make reference to the Constitution. The Constitution is clear, Section 175 of the 1999 Constitution. The Constitution is not against the president granting pardon. However, a pardon cannot be granted where there is still a pending appeal. There is a pending criminal appeal ongoing. So it is just the length of time. And this also brings me to talking about the committee, because I would believe that the committee should be able to ascertain that this matter is still pending. There is an ongoing appeal. So I don't know, I'm shocked that, such occurred. So generally, yes, following the Constitution, the president has the right to grant such pardon. However, such has to be done, where there is no pending matter
in court,
ongoing in the courts.
Okay, so yes. The Attorney General of the Federation, while explaining on this, said inclusion in the recent presidential pardon was on compassionate grounds and in the best interest of her children. So we understand that the law is sacrosanct, right? But then should this consideration carry some sort of legal or maybe a moral weight?
Well, the last time I checked, and if my memory serves me right, the Constitution has not been amended to reflect that. And as such, we cannot consider pitiable circumstance, or I would say pitiable circumstance cannot override a valid conviction. So that is, let it be shown that this is what the Constitution says. And as far as I'm concerned, the Constitution doesn't provide for such.
All right, so more broadly, Mary, is capital punishments not too excessively harsh in some instances, if I could put it that way, for a culpable homicide case?
Only if the Constitution can be amended and probably can be backdated to, impute all this. I would say, as far as the Constitution has not been amended, this act still constitutes Nigeria, is still under Nigerian law and shall continue to stand.
Okay, so to this last question, maybe before I let you go. Now, an Abuja High Court sentenced her to death on January 27, 2020, and we are in 2025. So why has the case remained unresolved from that time up until now?
That is the interval of 5 years. Well, I would say that the court is always careful such that there is there is nothing like miscarriage of justice. Cases like this naturally take time, and it is just to be able to review evidences and just to do the needful. Like I said, just for there to be proper justice to be done judicially and judiciously, and for there to be no miscarriage of justice. So that is what I would say.
Yeah, all right, we understand. Thank you so much, Mary Odewuyi, for sharing your legal angles with us on the news. I want to say happy birthday to you. I understand that today is your birthday.
Thank you very much.
Wish you all the best.
Thank you very much, sir. I'm most grateful. Thank you.
Of course.